ACDP, the Honorable Thring.
Thank you, Honorable House Chair. As I present this on behalf of Honorable Sukers, the ACDP views the Children's Amendment Bill as a critical response to the ongoing crisis in foster care, which has been placing vulnerable children at risk for more than a decade, precipitating the 2011 North Gauteng High Court ruling, instructing government to develop a comprehensive legal solution to the crisis. The ACDP believes that this bill is flawed, and chief amongst the failures has been the Department of Social Development's unjustifiable tardiness in creating this legislative solution some 11 years in the making. And as the latest court deadline approaches in November, pressure was brought to bear on Parliament to push the bill through, regardless of whether or not it solves the crisis and regardless of its impact on the vulnerable. Parliamentarians must develop legislation which creates meaningful change to those affected. In this case, the affected are our most defenseless citizens, the orphaned and vulnerable children. However, confusion around which clauses actually solve the problem in foster care and unwillingness to accept that other clauses in the original bill are of critical importance and should have been included in the final version, and interference from the executive resulted in the bill being pushed through with what some have called indecent haste. Despite extensive public consultation, political expediency led this bill being approved without clause-by-clause debate and without the committee considering all options for keeping children out of foster care, including allowing family care where there is a capable father. This can only be viewed as a failure to honor the democratic process that allows for every input to be duly considered. And when opposition parties protested, they were accused of politicking or delaying the bill. The resultant decision to exclude the amendments to Section 21 from the bill will have a significant impact. Though approved by Cabinet and widely accepted by civil society, the clause was considered too controversial and needing more consultation. However, by excluding it, the bill now fails to provide legal recognition and certification for unmarried fathers living with maternal orphans, which would enable them to protect and care for their children and act as their legal guardian. The consequence is that many maternal orphans will remain in the foster care system, despite having a committed father eager to raise them. As the minority report shows, the parliamentary process has produced a bill that only partially delivers on its promise to solve the foster care crisis, a bill that still fails to enable unmarried fathers to keep their children out of foster care, and a bill that could potentially make obtaining assistance harder for some vulnerable children. As such, the ACDP considers this bill to be a missed opportunity and will not support it. Thank you, Chair.